Good day, everyone. Welcome to this week's edition of Immigration Matters with Vissia Calderon, only here at Home Sweet Home. This week, we will answer an email sent to me by John, who wants to file a petition for his son, whom he had not seen for almost 20 years. He asks, I'm now a naturalized United States citizen. I have a son who's now 20 years old, and I have not seen him since he was 1 year old. His mother and I are not married. Can I petition for my son to come to the United States? This is a very common scenario that I have seen among my clients, and I can tell you that given the right evidence, John can file a petition for his son despite the son's illegitimacy and the fact that they have not seen each other for 20 years. This is what we call out-of-wedlock cases. And here, it's very important to show that aside from the fact that this is John's biological child, a bona fide parent-child relationship existed between the father and his child before the child reached 21 years of age, despite his son's illegitimacy. So, if John is supporting his child financially, we can show money remittances or financial support to the child. Show that John, as the petitioner, continued to support his son by paying for his education, housing, food, and other basic needs. If John acknowledged the child's paternity and his name appears in his child's birth certificate, baptismal records, school records, these are good evidence as well, and I'd like to see that. If he regularly communicates with his son or even the mother regarding his child's welfare through phone calls, Skype, Facebook, chats, emails, snail mails, let's give the government copies of these proofs of communication as well. Maybe he calls his son to ask him about what's going on in his life, disciplines him when necessary, and exercises parental care and concern for his son. The government would want to see that. If there were pictures when John and his son lived together, as well as pictures that they exchanged through the years, let's show those as well. In short, we need to prove that despite the illegitimacy, the father continued to do what a parent should do and showed parental concern for his son. The process requires filing a petition for his son and going through an immigrant visa application process and an interview at the U.S. Embassy abroad. Nowadays, it's taking approximately 6 to 8 months to complete the entire process. You have to note also that in some instances, the government may also want a DNA test done on John and his child to prove paternity. In that case, we just have to comply with it. Thank you very much for your question, John. If you have immigration questions, feel free to send me an email at vissia@vcalderonlaw.com or call our office at 702-932-7656. I'll do my very best to answer them right here on Immigration Matters with Vissia Calderon. Thank you, and I look forward to seeing you again next week. Same time, same channel. Attorney Vissia Calderon at your service.